des religions. Ah, ah, vous aurez l'occasion de poser cette question. Docteur en sciences des religions à l'école pratique des hautes études. Kahina Barloul est donc, je l'ai dit, islamologue, juriste, et elle est aussi conférencière, spécialiste de la pensée d'Ibn Arabi, du droit islamique, du soufisme et des dynamiques de genre en islam. Ces travaux articulent l'héritage classique de la pensée islamique avec les enjeux théologiques, juridiques et socio-contemporains en mettant l'accent sur les droits des femmes, le dialogue entre les cultures et le renouvellement de la pensée musulmane par une herméneutique inclusive. Lauréate du prix Mar Nostrum 2022 pour Mon Islam, ma liberté. Elle est également co-autrice des femmes et des dieux, publié dans Les Arènes en 2021. Docteur Barloul, vous avez la parole. Bienvenue.
Bonjour à toutes et à tous. Je sais pas, est-ce que vous m'entendez bien? Oui, alors. Oui, donc, alors je vais revenir quand même sur ma présentation puisque ça a suscité des interrogations. Alors je suis ici à Arusha en tant que chercheur en islamologie, en tant que docteur en islamologie, diplômé de l'école pratique des hautes études à Paris. Et juste en deux mots pour que... J'aimerais revenir sur ce qu'est cette discipline de l'islamologie. En fait, l'islamologie est l'étude scientifique de l'islam qui englobe tous les aspects de la religion musulmane, c'est-à-dire les textes, l'histoire, la théologie. Mais lorsqu'on parle de l'histoire, on parle de l'histoire politique, sociologique et de l'histoire des idées également. Parce que l'islam que nous connaissons aujourd'hui ou que nous voyons à travers le monde musulman, eh bien, il a subi tout un tas d'évolutions, de transformations, contrairement à ce qui peut être imaginé. Quelquefois, on a tendance à croire que la religion est immuable et qu'elle n'est jamais influencée par la main de l'homme ou par la pensée humaine. Donc il est important d'utiliser aujourd'hui dans les sciences modernes, nous utilisons des outils de la pensée moderne, des sciences humaines et sociales, afin de comprendre les phénomènes religieux, et notamment en ce qui me concerne l'islamologie. Donc les outils, c'est l'anthropologie, l'ethnologie, la philologie, la linguistique, et tout un tas de disciplines des sciences humaines et sociales pour comprendre les textes religieux, les pratiques religieuses, les croyances religieuses, leurs fondements et souvent aussi Cela permet aussi, lorsque nous observons des phénomènes sociaux qui nous interrogent, eh bien, ces outils-là nous permettent aussi de déconstruire certaines croyances qui semblent inadaptées, qui sont inadaptées en tout cas à notre époque. Et donc c'est la raison pour laquelle, en tout cas moi, c'est la méthode que je vous proposerai aujourd'hui en tant qu'islamologue. Et pour revenir juste peut-être en 2 secondes sur la question de l'imamat de la femme, alors c'est vrai, dans le monde dans le monde musulman, on a du mal à imaginer qu'une femme imam puisse exister, mais il faut savoir qu'en Chine, les femmes existent depuis le XVIIIe siècle. Il faut savoir également que dans la tradition prophétique du prophète Mohammed, dans les recueils canoniques, notamment de Musnad ibn Hanbal, on retrouve l'histoire d'une femme qui a été nommée par le prophète Mohammed lui-même pour être imam. Elle s'appelait Waraqa. Mais les traditions patriarcales, les interprétations patriarcales et très masculines ont toujours exclu tout ce qui concerne l'action ou la pensée de la femme dans la religion. Voilà, juste en 2 secondes. Alors moi, mon intervention, oui, c'est celle-ci, revient sur les violences faites aux femmes dans le contexte du système juridique coutumier islamique. Et oui, donc je peux bouger avec ça, c'est ça? Ah, voilà. Oui, et donc je vous ai mis pour commencer cette carte afin que l'on puisse voir un peu les pratiques des mutilations génétiques féminines en Afrique. Un sujet, j'avoue, dont on ne parle pas assez, qu'on méconnaît. J'ai eu l'occasion, là, depuis hier, par exemple, de discuter avec les uns et les autres sur ces pratiques-là, l'excision notamment. Et c'est vrai que les gens me disent oui, mais on n'en parle pas, on ne connaît pas ces pratiques-là. Et puis on a l'impression que c'est tellement loin de nous qu'on ne sait pas vraiment à quelle échelle cela est pratiqué et quelles conséquences cela peut avoir sur les personnes, enfin les citoyens des pays africains notamment, puisque c'est le sujet qui nous occupe aujourd'hui. Alors on peut voir sur cette carte que les pays où on retrouve le nombre le plus important de victimes, donc de femmes qui subissent ces mutilations, se trouvent notamment dans les pays comme l'Égypte, le Mali, la Somalie, là où il y a la couleur bordeaux foncé. Donc là, on voit bien que la pratique des MGF, de l'excision, est pratiquée à une très large échelle dans ces pays-là. Et puis après, on retrouve donc ce dégradé de couleur où l'excision est encore pratiquée, y compris dans le pays où nous nous trouvons aujourd'hui, en Tanzanie. Donc moi, mon propos aujourd'hui, ça va être d'essayer de voir quels sont les fondements religieux, les textes religieux sur lesquels se fondent les partisans des MGF, et essayer de voir est-ce que leur justification est vraiment fondée, ou alors est-ce qu'on peut déconstruire leurs arguments religieux. Et on va voir que, bien évidemment, tous ces arguments religieux peuvent être remis en cause, questionnés et déconstruits. Donc, certaines pratiques violentes sont justifiées à tort par la religion islamique alors qu'elles relèvent de la tradition patriarcale ou culturelle. C'est vrai que l'excision existe dans certains pays musulmans depuis des siècles et des siècles, bien avant l'avènement de l'islam. Et donc, ce n'est que la perpétuation de ces traditions-là anti-islamiques qu'on va retrouver aujourd'hui, mais on va les adosser à un argument religieux pour leur donner un caractère sacré et donc quasiment intouchable. Donc il est essentiel de différencier les textes religieux, le Coran, le Hadith, de leur interprétation humaine, souvent influencée par la culture et le patriarcat. Donc l'objectif de cette présentation est d'identifier les pratiques violentes perpétrées au nom de l'islam, analyser leur origine, les déconstruire pour mieux pouvoir les combattre. Donc l'islam est profondément ancré dans diverses régions d'Afrique où les pratiques sociales sont souvent le résultat d'une fusion entre les enseignements islamiques et les traditions pré-islamiques, c'est-à-dire les traditions qui existaient déjà avant l'avènement de l'islam. Ces traditions, bien que non islamiques, continuent d'exercer une influence significative sur les comportements et les normes sociales, ce qui peut mener à des interprétations erronées des textes religieux. Donc moi, je vais vous proposer de voir pour chaque pratique les textes religieux sur lesquels se fondent ceux qui les pratiquent et de voir s'ils ont raison de le faire. Alors, les mutilations génitales féminines, une perspective critique. Lorsque je parle des mutilations génitales féminines, je parle notamment de l'excision. L'excision sous toutes ses formes, parce qu'il existe plusieurs formes d'excision, paraît-il 4 formes, de la plus radicale à la plus légère, on va dire. Donc, ces MGF sont souvent présentées comme des obligations religieuses, mais elles sont en réalité des pratiques culturelles, comme je le disais, qui varient considérablement d'une communauté à l'autre. Et d'ailleurs, on observe à ce propos, dans la carte que je vous ai montrée tout à l'heure, qu'il y a des pays où cette pratique-là n'existe pas, comme par exemple dans les pays d'Afrique du Nord, comme la Tunisie, l'Algérie et le Maroc, où l'excision n'est pas pratiquée. Donc on voit bien que ce n'est pas tellement le facteur religieux qui incite à cette, ou en tout cas ce n'est pas vraiment le fondement qui est à l'origine de cette pratique. Ces interventions sont souvent justifiées par des croyances erronées sur la pureté et la moralité. Donc on va dire que l'excision en fait va favoriser la moralité de la femme parce que ça va calmer, on va dire, ses ardeurs et sa libido. Ou alors, pour d'autres, l'excision va être, l'argument pour l'excision va être la pureté de la femme. Cependant, lorsqu'on parle de droit musulman, il y a les fondements du droit musulman. Dans le droit sunnite, dans le courant sunnite, donc en islam, alors les 2 premiers textes fondateurs dans lesquels on va puiser les normes religieuses, on a d'abord le texte coranique, et puis après on va avoir tout le corpus du hadith, c'est-à-dire c'est toute la sunna qui est attribuée au prophète. Alors ça peut être ses dires, des choses qu'il a dites, ou alors des comportements que lui-même a eus de son vivant, ou alors des approbations qu'il a, ou alors des approbations de certaines pratiques de son vivant. Cependant, il faut rester très très prudent à propos du hadith. Donc ça, c'est vraiment la définition qui est faite du hadith dans la tradition musulmane. Cependant, lorsqu'on étudie le hadith, comme je vous le disais, d'un point de vue scientifique, eh bien, le hadith reste largement une littérature qui a plutôt émergé de façon très tardive après la mort du prophète. Donc c'est une c'est une littérature qui va plus nous renseigner sur les croyances et l'évolution de la religion au moment où cette littérature a été posée et produite, plutôt que sur la vie du prophète lui-même. Je vous le redirai plus tard, quand on verra les conclusions de notre exposé. Le hadith a été, les principaux recueils de hadith ont été globalement produits 2 à 3 siècles après la mort du prophète. Donc on peut se questionner sur l'authenticité de ce corpus-là. En ce qui concerne les MGF, alors on ne retrouve absolument rien qui nous parle de cette pratique dans le texte coranique. Donc le texte coranique qui est le premier fondement de la loi religieuse islamique. Donc le deuxième fondement qui est le hadith, là on va voir qu'il y a plusieurs hadiths sur lesquels se fondent les partisans des MGF. Moi je vous ai cité 3 hadiths les plus connus, les plus utilisés, mais voilà, leur imaginaire est tellement riche que quelquefois ils s'autorisent vraiment à se fonder sur des hadiths complètement improbables. Alors le premier hadith est celui de hadith Atiya. Le hadith de Atiya, on raconte à propos de cette femme qu'elle pratiquait l'excision à Médine, à l'époque du prophète. Et donc, ce hadith est souvent cité pour légitimer les mutilations génitales féminines. Mais son interprétation est sujette à controverse. Alors, que dit ce hadith? Le hadith dit en arabe « O Atiya akhfiri » ou bien « Ashimmi wa la tanhaki », ce qui veut dire en français « O Atiya, diminue légèrement et n'exagère pas, car agir ainsi préservera la beauté du visage de la femme et contentera le mari. » Alors, les études, bien évidemment, concernant le hadith, les études en islamologie notamment, ont démontré, et d'ailleurs même dans la tradition, pas uniquement les études contemporaines, ont démontré que la chaîne de transmission, le sanad de ce hadith, est considéré comme très faible. Alors je reviens juste sur la structure du hadith pour que l'on comprenne bien les études qui sont faites sur le hadith. C'est que le hadith, il est constitué donc de deux parties. Il est al-matn, ce qu'on appelle le matn, c'est-à-dire le texte lui-même du hadith, qui va nous donner, nous apporter un enseignement ou la parole du prophète. Donc ça, c'est le matn. Et puis après, on a al-isnad, ou le sanad. Le sanad, c'est la chaîne de transmission qui va reconstituer toutes les personnes qui ont rapporté ce hadith depuis le prophète jusqu'à la personne ou le traditionniste qui a écrit effectivement ce hadith dans son recueil de hadith. Alors on connaît dans cette littérature, il y a énormément de recueils de hadith. Les plus connus, vous avez ceux des quatre imams des quatre écoles sunnites, l'imam Malik pour l'école malikite, le Shafi'i, et on va retrouver aussi le Musnad de Ibn Hanbal, comme je vous le disais, et différents autres recueils. Donc, cette discipline des sciences religieuses à son époque, qui est apparue à peu près, donc je le disais, au IIe siècle de l'Hégire, c'est vraiment, à cette époque-là, c'est une discipline qui a eu beaucoup de succès. Parce que beaucoup de muhaddithoun, quand on disait à l'époque un muhaddith, c'était vraiment quelqu'un, un grand savant. Ibn Hanbal, par exemple, était considéré comme un grand muhaddith. Et donc, il y a eu à cette époque-là une profusion, une surproduction de ces recueils de hadith. Et on connaît, y compris dans la tradition religieuse musulmane, dans les études classiques, on sait bien que il y a eu beaucoup de recueils et beaucoup de hadiths qui ont été forgés, et on connaît les histoires de certains recueils qu'on a fini par enterrer parce que vraiment on a considéré qu'ils étaient complètement forgés. Mais le problème, c'est que à partir du moment où ces hadiths-là ont été diffusés dans l'oralité, dans la transmission orale de la société, il a été difficile par la suite de savoir quels étaient les hadiths authentiques ou pas. Et d'ailleurs, même lorsqu'on parle de Sahih Muslim et Bukhari, en fait, il ne faut pas croire que tout ce qu'il y a dans Sahih Muslim et Bukhari est authentique. Ce n'est pas le cas. Donc, comme je vous le disais, je reviens à ce hadith qui sert d'argument à l'excision. Sa chaîne de transmission est considérée comme étant faible, donc inauthentique, ce qui signifie qu'il ne peut pas être utilisé comme fondement pour des pratiques religieuses et notamment des mutilations génitales féminines. De plus, il s'oppose aux enseignements du texte coranique et prophétique sur le caractère sacré du corps humain, où on retrouve effectivement un verset qui nous dit « La tabdila li khalqillah » on ne peut pas changer la création de Dieu. Donc voilà concernant ce hadith. On va retrouver ensuite un autre hadith, hadith d'Al-Hajjaj ibn Arta. Alors, ce hadith nous dit Al-Khitan sunnatun lirijal wa makruma lin-nisa. La circoncision est sunna pour les hommes et un honneur pour les femmes. Alors, le problème de ce hadith, c'est qu'il a été interprété de deux façons différentes. La première est celle de ceux qui prônent les MGF. Et ils disent que, en fait, donc, ça parle de al-khitan, et ils disent qu'à l'intérieur du mot khitan, on peut mettre non seulement le khitan pour l'homme, la circoncision de l'homme, mais aussi l'excision. Or, on verra plus tard que l'excision pour la femme, en fait, c'est pas ce terme-là qui est employé en langue arabe. C'est en général le mot khifab, on le verra après. Mais donc ceux qui sont pour ce hadith, pour l'excision avec ce hadith, ils disent, donc ils mettent dans ce mot khitan les deux genres. La circoncision de l'homme, et ils disent que, alors c'est une sunna pour l'homme, c'est-à-dire que c'est vraiment quelque chose d'encouragé, hein, c'est une sunna. Ou un makruma linisa. Alors makruma, c'est un honneur. Elle n'est pas au même degré que la sunna, mais c'est quelque chose de bien, c'est un honneur. Mais il y a une autre interprétation qui est faite de ce texte-là, de ce hadith-là, où il est important de distinguer les deux parties du hadith. Donc, on parle d'abord de al-khitan sunna lirijal, ok. Ou makruma linnisa, là ils vont vous dire non. En fait, lorsqu'on dit que c'est une makruma linnisa, ça veut dire que les femmes qui épousent un homme circoncis, eh bien c'est un honneur pour elles. Et non pas, et on parle absolument pas ici de l'excision, mais plutôt du fait d'épouser un homme, donc dont parle la première partie, le fait d'épouser un homme qui est circoncis est un honneur pour sa femme. Donc voilà la deuxième interprétation qui semble être la bonne, la plus, qui a du bon sens et qui n'est pas donc pro-mutilation des femmes. Ensuite, on va avoir le troisième hadith, donc le hadith de Aïcha. Alors ce hadith nous dit إذا التقى الختانان فقد وجب الغسل. Ce qui veut dire lorsque les deux khitan, ce qui veut dire, alors en langue arabe, le mot khitan est employé pour la circoncision, mais il peut être aussi employé pour désigner les parties génitales ou le sexe. Et donc ce hadith nous dit lorsque les deux khitan, les deux sexes se rencontrent, ce qui est une métaphore pour parler de la relation sexuelle, et en fait pour nous parler ensuite de l'obligation après cet acte sexuel de devoir faire ces grandes ablutions. Et en fait ce hadith, lorsque on étudie l'endroit dans lequel il se retrouve dans les recueils de hadith, eh bien on va le retrouver toujours dans le chapitre qui concerne at-tahara, qui concerne la purification rituelle. Donc, c'est un hadith qui est destiné d'abord à la question de la purification rituelle et non pas à la circoncision ou l'excision. Sauf que, eh bien, les partisans des MGF vont l'interpréter encore une fois d'une autre manière en disant, alors, puisque le mot khitan est employé en langue arabe, on peut employer un mot al-muthanna, c'est-à-dire pour désigner un duo, al-khitanani. Donc il y a deux khitan. Et donc ils vont vous dire, dans ce cas-là, on parle du sexe de l'homme et puis aussi du sexe de la femme. Ce qui veut dire que al-khitan est aussi valable pour la femme. Et là, c'est pareil, ils vont employer encore une fois ce mot khitan qui est destiné au départ à la circoncision de l'homme, encore une fois, pour la femme. Et là, je vous ai mis, il faut faire attention aussi, il faut avoir une bonne connaissance de la langue arabe pour pouvoir déconstruire ce type de croyances et d'interprétations. En langue arabe, il est tout à fait acceptable d'employer un même mot pour désigner deux choses différentes mais qui sont proches au départ. Je vous ai mis des exemples ici. Par exemple, pour désigner les deux compagnons du prophète Omar et Abu Bakr, on va dire Al-Omarayn, les deux Omar. Ou alors, par exemple, pour désigner la mer et puis un fleuve, on va utiliser le mot les deux mers, Al-Bahrain. Mais en réalité, c'est pour désigner un fleuve et une mer. Donc c'est vraiment un style, on va dire, un style linguistique en langue arabe qui est tout à fait acceptable et qu'il faut connaître. Et donc il faut du coup faire attention au fait que al-khitanan ne veut absolument pas dire les deux sexes, et donc la circoncision et l'excision. Donc voilà pour la déconstruction des ahadiths qui sont utilisés pour l'excision. Venons-en maintenant à un autre sujet qui est celui des mariages forcés et précoces. Alors, les mariages forcés sont souvent justifiés par des interprétations erronées de textes religieux, comme pour les MGF et tout un tas d'autres pratiques. Et malheureusement, ils privent les jeunes filles de leur droit à l'éducation et à l'autonomie et à vivre leur jeunesse, à grandir avant de choisir de se marier. Alors, il y a notamment ce qui est rapporté à propos de l'épouse du prophète, Aïcha, qui est souvent employée pour justifier le mariage des fillettes. Eh bien, il y a cette croyance que Aïcha aurait été promise au prophète par son père Abu Bakr à l'âge de 6 ans et que le mariage a été consommé à l'âge de 9 ans. Le problème, c'est que les hadiths qui sont invoqués pour l'âge de Aïcha, on va retrouver un rapporteur qui s'appelle Hisham ibn Urwa. Et on dit à propos de ce rapporteur qu'à la fin de sa vie, il a un peu perdu la mémoire et donc il racontait quelquefois des hadiths qui étaient complètement faux ou approximatifs. Et aujourd'hui, donc dans les études, dans la recherche en islamologie, on a complètement remis en cause cette affirmation sur l'âge de Aïcha et on évalue aujourd'hui l'âge de Aïcha lorsque le mariage a été consommé avec le prophète à entre 17 ans et 19 ans. Maintenant, voyons les violences conjugales. Alors là, on va il s'agit plutôt de textes coraniques, de versets coraniques, et non pas de hadiths. Mais là encore, il s'agit d'interprétation du hadith. Le verset qui est employé, c'est le verset 34 de la sourate 4. Et il dit « Quant à celles dont vous craignez la rébellion, exhortez-les, éloignez-vous d'elles dans les lits, et séparez-vous d'elles. Adribuhunna. En fait, c'est vraiment ce terme adribuhunna qui pose question. Alors en arabe, c'est wallati takhafunna nushuzahunna fa'idhuhunna wahjuruhunna fil madaji'i wadribuhunna. Wadribuhunna en langue arabe, eh bien, il peut avoir plusieurs sens. Mais il peut avoir le sens de frapper. Mais ici, donc aujourd'hui, avec toutes les relectures contemporaines qui sont faites et pour être en cohérence avec la protection des droits de la femme, eh bien, ce terme adribuhunna est plutôt traduit par séparez-vous d'elles et non pas frappez-les. Parce que le mot adrib peut avoir aussi le sens de séparer, se séparer. En ce qui concerne al-wali, la tutelle masculine sur la femme en islam, alors il y a ce verset donc, de la sourate, c'est toujours le même verset, hein, le verset 34 de la sourate 4, qui dit « Ar-rijalu qawwamuna ala nisa bima faddala Allahu ba'dahum ala ba'din wa bima anfaqu min amwalihim » Les hommes sont responsables des femmes en vertu. Alors vous voyez, moi je le traduis responsable, c'est une traduction tout à fait valable. Et beaucoup le traduisent responsable aujourd'hui. Mais malheureusement, pour légitimer encore une fois l'autorité des hommes et la tutelle masculine sur les femmes, souvent le mot qawwamun est plutôt traduit par ils ont autorité. Les hommes ont autorité sur les femmes. Alors qu'en réalité, ce qu'il veut dire ici, ce mot-là, qawwamun, il veut dire les hommes sont responsables des femmes en vertu de ce que Dieu a donné la préférence à certains sur certains. Et d'ailleurs, on voit ici que faddala Allahu ba'dahum ala ba'din. Il n'y a pas de genre à ces deux mots, ba'dahum ala ba'din. C'est-à-dire, l'un et l'autre peuvent à un moment donné être responsables ou alors subvenir aux besoins de l'autre. Et donc l'homme et la femme sont complètement interchangeables dans cette formule de ce verset. Et donc voilà pour ce verset. Alors maintenant, venons à la question du voile forcé. Alors, le voile, lorsqu'il est choisi, il n'y a absolument aucun problème. Chaque femme a le droit de choisir la tenue vestimentaire qu'elle a envie de porter. Mais on va retrouver des cas de voile forcé et la volonté de contrôle du corps de la femme. Et il y a aussi, alors le voile forcé, il peut y avoir une coercition matérielle qui est exercée sur la femme, mais ça peut être aussi une pression sociale à propos de cette croyance que le voile est une obligation. Et là, on va retrouver 3 versets coraniques aussi, qui sont sur lesquels se fonde cette question du voile. Alors, on emploie pour le voile le mot hijab. Et en fait, là, le mot hijab, on va le retrouver dans un verset coranique qui nous parle des épouses du prophète. C'est un verset qui invite les personnes qui viennent de l'extérieur pour rendre visite au prophète. En fait, le prophète était extrêmement gêné par ces visites nombreuses qui venaient chez lui, où vivaient ses épouses. Et donc ce verset est venu pour dire, lorsque vous voulez rendre visite au prophète, attention, ne rentrez pas comme ça chez lui, mais adressez-vous à ses épouses à travers un hijab. Donc ici, le mot hijab ne veut absolument pas dire un foulard ou un voile sur la tête, mais plutôt une cloison ou un rideau, c'est-à-dire quelque chose, une séparation entre la sphère intime, la sphère privée et la sphère publique. Donc là, il ne s'agit absolument pas du hijab, du mot hijab comme il est employé aujourd'hui pour signifier le voile, le foulard. Ensuite, on a ce deuxième verset qui représente aussi un fondement pour ceux qui veulent imposer le port du voile. Et ce verset, il dit aux croyantes de baisser leur regard, de garder leur chasteté, de ne montrer de leurs atours que ce qui en paraît, et qu'elles couvrent de leurs étoffes, al-khumur, c'est le pluriel de khimar, et donc qu'elles couvrent de leurs étoffes leur décolleté, al-juyub. Al-juyub, il peut être traduit, alors là j'ai mis décolleté, mais juyub veut dire les échancrures, les ouvertures en langue arabe. Donc il s'agit là, on fait référence au décolleté. Donc là, encore une fois, il ne s'agit absolument pas de désigner la tête ou les cheveux de la femme, mais plutôt cette partie donc, du décolleté de la femme. Ensuite, on va retrouver ce troisième verset qui nous parle du djilbab. Le verset, il dit « Ô prophète, dis à tes épouses, à tes filles, aux femmes des croyants, de tirer à elles, yudnina, les pans de leurs vêtements de dessus, jalabib, au singulier djilbab. Ceci est plus à même à ce qu'elles soient reconnues et à ce qu'on les offense point. » Et donc ici, il s'agit de reconnaître la femme musulmane. Et on retrouve dans l'exégèse classique ou les commentaires classiques du Coran asbab al-tanzil, ce qu'on appelle asbab al-tanzil, ou les causes pour lesquelles ce verset a été révélé dans le Coran. Et les asbab al-tanzil sont le fait qu'à l'époque, il n'y avait pas de toilettes à l'intérieur des maisons. Et la nuit, lorsque les femmes sortaient pour faire leurs besoins à l'extérieur, eh bien, elles pouvaient être agressées. Et donc, ce verset a été révélé pour dire, dites à vos femmes, aux croyantes, aux musulmanes, de rabattre sur elles leur long manteau pour qu'elles soient reconnues comme étant musulmanes et qu'on ne les importune pas. Et on va voir aussi que dans la linguistique, le mot djilbab n'a rien à voir avec le djilbab que nous voyons aujourd'hui. En fait, le djilbab que nous voyons aujourd'hui, c'est une évolution très contemporaine et actuelle de cette tenue-là. Le djilbab, à l'origine, à cette époque, au 7e siècle, voulait dire chemise ou alors un long manteau, un long manteau qui pouvait avoir une ouverture sur le devant, etc. Donc ce n'est pas le djilbab que l'on voit aujourd'hui. Et donc enfin, j'aimerais juste partager avec vous quelques conclusions des recherches contemporaines, des recherches en islamologie à propos du corpus du hadith. Donc de 1880 à 2025, il y a eu vraiment énormément de recherches sur le corpus du hadith dans les plus grandes universités occidentales dans le monde. On a l'école allemande qui a été très riche, notamment. Il y a eu aux États-Unis aussi des recherches très intéressantes, en France, voilà, un peu partout en Occident et aussi dans le monde musulman, les quelques penseurs réformistes. Et donc on en est arrivé au constat que le hadith est un corpus hétérogène produit du 2e au 3e siècle sur 2 à 3 siècles dans des contextes de conflits politiques, sociaux et juridiques. Donc ce qui a profondément façonné et influencé le contenu de ces hadiths-là. Il existe un écart historique majeur entre l'époque de Mohammed, le 7e siècle, et le moment auquel on a produit tous ces recueils de hadiths qui apparaissent donc plutôt au 9e et 10e siècle. Donc une partie significative de ces récits invoqués pour légitimer violence, domination ou discrimination n'est pas prophétique, mais postérieure, contextuelle et idéologique. Ainsi, il convient d'être prudent dans l'usage du hadith pour produire une norme religieuse. Donc l'islamologie contemporaine a démontré qu'une large part du corpus a été forgée ou remodelée. Donc là, je vous ai mis quelques mots de grands chercheurs islamologues qui ont réussi à vraiment travailler sur une... Ils ont fait un travail colossal sur le corpus du hadith, c'est-à-dire qu'ils n'ont pas travaillé uniquement sur un seul recueil ou deux, mais sur un très large nombre de hadiths. Et ils sont arrivés aux conclusions que de nombreux hadiths reflètent des intérêts politiques à l'époque omeyyade et abbasside, des conflits théologiques concernant la foi, le péché, les autorités, des enjeux sociaux, de genre, de statut, concernant l'esclavage aussi, et de lutte entre les écoles juridiques. Et donc le hadith est plutôt une production historique et pas un témoignage direct du prophète lui-même. Les chaînes de transmission ne prouvent absolument pas l'authenticité. Les isnad, ou ces chaînes de transmission, ont été régularisées, allongées, harmonisées, donc souvent retouchées ou alors créées pour... bien évidemment, les gens qui ont forgé ces hadiths, ils connaissent très bien quels sont les transmetteurs les plus connus, les plus grands transmetteurs de hadiths pour pouvoir recréer des chaînes de transmission. En conclusion, les violences faites aux femmes au nom de l'islam ne sont pas fondées sur des arguments scripturaires, mais sur de fausses interprétations et une instrumentalisation de la tradition prophétique pour perpétuer des croyances, des traditions et des coutumes anti-islamiques ou idéologiques. Et voilà, je vous remercie.
Thank you very much, Dr. Bahloul. You have provided clear understanding of these hadiths and the issue of treatment of women in Islam, understanding. I'm sure there will be questions, and I would like to request that you note your questions, and we allow the remaining presenters to finish their presentations, and then there will be questions and answers session, combining all these presentations here. Can we do it like this? Thank you. Now, I have the pleasure to introduce the next two presenters, starting from Mr. Peter Apuko Auni, who is a practicing lawyer and doctoral candidate at the University of Ghana School of Law. And he is an alternative dispute resolution specialist. He is the head of the law department of the national NCUK, is National NCUK. That's the name of the university, right? Good. In Accra, International Study Center. He is a doctoral fellow of the Institute of Certified Business Analysts and Consultants of Ghana. He is the founder and director of the Center for Traditional Leadership, Culture, Conflict, Law, and Development, which is based in Ghana. Mr. Apuko, he is a specialist in matters relating to combating the violence against women, and he has done a lot of work in the area pertaining to discrimination. And the fight against discrimination is central to his advocacy, which is also prevalent in indigenous communities. The other presenter is Ms. Jacinta Peter. Ms. Jacinta Peter is a seasoned legal professional and principal state attorney at the National Prosecution Service in Tanzania. With over 15 years of experience in prosecution, legal advisory, and human rights advocacy, she holds a Master of Laws from the University of Dar es Salaam and a specialized Master of Laws in International Crime and Justice from the United Nations Interregional Crime and Justice Research Institute in collaboration with the University of Turin. Throughout her career, she has handled criminal and civil prosecutions at various court levels, provided legal aid, and contributed to policy development in various areas. She has also served as an advocate in private practice and as a legal officer at the Legal and Human Rights Center. And currently, she is a focal person of gender-based violence cases at the National Prosecution Service in Temeke District. Ladies and gentlemen, join your hands to welcome in the first place Mr. Peter Apuko Auni. Most welcome.
Good morning once again. As our friend is looking forward to share the slide, I would start by saying I love customary law. I love customary law. And as I look at how you look beautiful, I see legal pluralism around. Because I see that some of us are wearing our traditional wears, but you would also find a Western fabric going with that. That is our legal system that we practice. Like Prof has mentioned, I come from Ghana, and my presentation is on the topic examining how traditional justice systems can be harmonized with formal legal institutions to enhance women's access to justice in Africa. And my presentation is partitioned in two parts. The first part will look briefly into traditional justice systems in Africa, attempt to look at formal legal systems and how they came about, and our plural legal system, attempt to look at the concept of access to justice, and for that matter, access to justice to women, challenges that they face. Okay, thank you. My apologies. And we'll proceed to look at the second part looks at the proposed strategies. We are all familiar with the fact that before colonization, we had a way of governance, and this was led by our traditional leaders, religious leaders, kings and overlords and queen mothers, and we got our traditional leaders from royal families and lineages. And in brief, what do we even mean by customary law? And customary law, they are not written, and these are our lived experiences within our communities, but it guides us. And it is that those ones that our traditional leaders used to adjudicate matters, and which we are ourselves familiar with. So if I asked you that what is a taboo in your community, you would mention, but be a Muslim or a Christian. That shows that you are very much abreast with your traditional and customary laws. Notwithstanding the fact that we have all moved to belong to one traditional, one religion or the other. Our traditional systems and governance systems are more accessible. It is at our noses, as others will always say, you don't need any procedure, you just walk in and you are ahead. So it is actually very close to us, and it is cheaper as far as that is concerned. What is the scope of traditional justice system? Basically, it revolves around property rights, land ownership and usages and inheritance and all those things. But we should also pay attention to the fact that traditional justice system is not only about the chiefs and traditional leaders, but it is about us. It is about us. It is us, the community, who choose our leader by our laid-down procedures. So when we talk about traditional justice system, we should talk of it in a form of a society which includes the leader, and the leader being the custodian of our culture. So whatever they do, it appears that they are actually doing what is within the scope of our culture. However, when they veer, we are able to say that, oh no, this chief, what you are saying is not in our culture. This is wrong. This is not our culture, because he is only one person within the traditional systems that guides us or leads us. Our customary law systems and traditional justice system is founded on some philosophies which is unique about us. And in doing a bit of research, in my tribe, which is the Frafra tribe, we have what we call Mabito. Mabito simply means we are children of the same mother. So that impacts in how we resolve disputes and conflicts. So if somebody even offended you and you are a woman and you wanted to proceed, we say, oh, but you are Mabito, you are children, you are from one mother, you are from one parent, even though you have been abused. Now in the account we have what we call Minua. And I've been in my research, I came across and I have been mentored and taught this morning again in Ujamaa, which is Ujamaa. Thank you very much. And it is the same thing together. And we have Ubuntu, right? The South Africans will talk about Ubuntu and Gachacha. So we have it. So in every part of our communities in Africa or societies, you realize that we are just one people. And we have our ways. Ghana's story is not any different from many of our African states who were colonized. And we remember our 3 C's, right? That they came to do colonization, civilization, and Christianization. And maybe I want to say Islamicization. Yes. So by that, it also corrupted the way our traditional justice system is. I actually even wanted to get that, chameleon. But it's frightening, right? That reptile is frightening. But I wanted to actually show it because that is how customary law looks like. It resembles its background. It's that flexible. So when it changes, when the formal system changes, it changes and follows it. That's how come when Prof was talking yesterday about the return of FGM, I was just smiling because it doesn't just die. Customary law doesn't die, it changes. When you change this way, it will change, but it will still exist. So that is how it is. And is the traditional justice system still relevant and effective in Africa? This I want to demonstrate in these situations that happen in Ghana. Very interesting situations. And we have our traditional leader, that you find one of our traditional leaders there, and that is our former president there. And our former president visits him and orders him to stand up. And he refuses to stand up. Yeah. That was, for me, the height of the clash of the former justice system and the traditional justice system. So who was now powerful at that particular event? Because it's power play. Who is more powerful? And in our customary system, when the former legal system clashes with the customary law, the former legal system will fall. Because it is understandable that the chief in this jurisdiction is the owner of the people. So when you are a president or a minister and you come before the chief, a chief is not supposed to stand up to greet you. It's a taboo. It is not possible that a chief would, and even if you even find as a sub-chief or a community, a small community as the chief, if you are the president and you go to his community, you must first greet him first before you do anything. If you don't do that, he can tell the people not to come out. And they will not come out. So chiefs are very powerful in Ghana and are very much respected. So if you dare a chief, the chief can even ban that there will be politics in his traditional area, and you can't do that. You can be the president, but your party cannot undertake campaigning. So this particular chief banned the president's party not to do any partisan campaigning in his traditional area. And it does happen. So it does happen in Ghana. So if you are a minister or whatever you are, a former legal system, you must know that the chief is the chief. Yes. And our constitution actually guarantees chieftaincy in Ghana. And before you even make law as legislators and it is affecting chieftaincy, you must take it to the National House of Chiefs for them to make their comments. If they agree, it becomes law. If they disagree, it doesn't become law. So that is how it works. I'm attempting to look at legal pluralism. We can't do without it. We were there, they have come. We have now married. So we are living with it like that. But it does present a conflict of law situation. So in that particular situation, who is now the leader? Is it the customary law system which is leading, or is it what the justice system which is leading? So in this instance, when a traditional leader offends the law, how do you punish such a leader? How do you punish such a leader? And he's within the jurisdiction of what? Customary law practice and delivering justice. So how do you punish a traditional leader who actually abuses? And you are a political leader and you want to retain power. And you appoint attorney general. So would it go forth? So there was a case where a traditional leader we heard that he had married a teenager, and it was in Ghana, the society would not leave you the traditional leader. But the government and state are very technical about it. So when it came out, the traditional leader wasn't prosecuted, but the state did a lot of steps by going to pick up the young lady and rehabilitated, took her back to school and all those things. But that traditional leader, there's no information that that particular traditional leader has been punished. So that is where it is. So they will deal with it in a diplomatic way, rather than just going straight forward and doing what the law requires. Why? Because the traditional leaders are very powerful. So we have to deal with them in a diplomatic way. Legal pluralism. But what is so important about it is that we need to actually reflect on where we are going. Understanding the fact that customary law lives in the community. It lives in the community, far from the courts, far from the police. Until they come to report, then there's no issue. If they are suffering in their community and they go before a traditional leader to deal with the matter, that is it. So it means that we ourselves must understand their positioning, that they are that relevant and impactful that needs to be empowered. But I would ask a question. How many of our traditional leaders have we gathered like this to give them empowerment? How many of them are lawyers? How many of them are educated? How many of them are in tandem with the laws that change by the second? But you expect them to loosely. I always laugh at the legal principle which says that ignorance of the law is no excuse. I laugh at it because we have borrowed the economic principle, right? To say all things being equal, right? Meanwhile, things have never been equal. That's just a fair way of doing things in order to rope everybody into, when you know that traditional leaders are very central, but you don't empower them and they're actually adjudicating matters, and you still say that ignorance of the law is no excuse. But respectfully, you have your leaderships and judges here and better placed legal specialists than myself who would know that notwithstanding your capacity building, you still make errors of the law, fundamental errors of the law. Can you now imagine someone who hasn't been to school, by virtue of the fact that he's just a prince, makes a chief or a queen mother and handles matters? And you say that he's wicked. Is it that it's weakness or wickedness? Very important for us to look at. That perspective is very important. When you think that it is wickedness, your approach is different. When you think that it is weakness, then the approach is also different. But let's look at a bit of understanding of what is access to justice. In my research, it appears that the system should be fair. You should be able to get the necessary institution giving you a listening ear and helping you just as they will help a man. And who is a woman is very important for me. And yesterday, respectfully, it appears I didn't invoke the jurisdiction of the African court properly. So my question wasn't answered as far as interpretation was concerned. Respectfully, Prof, I believe you may want to do that for us today. It is important because we are here at a conference at a time in our existence that the question as to who is a woman is one we either run from or we don't want to talk about it. We say, just let it go. Just let it go. If we are here and supposed to be chief advocates are running away from it, who would go close to it? So we would need to confront it head on. So I asked, is it A, is it B, or is it C? Who is a woman? You know, they've just newly wedded couple. And let's assume that with C, the jurisdiction allows that kind of marriage, right? and now the supposed man is molesting the supposed woman. Is the woman, the said woman, covered under what we are doing here? Because you might get a society where the population of C increases and gets to that particular height. How do you treat such a woman? We should be thinking about that. It is very important for us to think aloud and prepare ourselves. And a recent decision of the UK court is refreshing. And that is for women, Scotland versus Scottish minister. In this particular, it is an interesting case because the government has a policy, and the policy says that, okay, this number of persons should represent women, and LGBT persons, transgender persons want to also represent on the board, representing women. For women say no, we will not agree because as far as the interpretation of the Equality Act, you are not supposed to go and represent us, so we are not going to agree. The debate goes forth and back, and finally, the court's decision says that under the Equality Act 2010, the word sex, man and woman, refer to biological sex only, not certified or acquired gender by the gender recognition certificate. Now, that is telling. It means that if it comes to representation and advocacy for women, it is biology. But any other matter, you can enjoy. Non-discriminatory. This is sharply different from the case of Godwin, and which was decided by the European Court, which was saying that no, UK, you can't do that. A woman is a woman. It doesn't matter whether it's a transgender person. But perhaps because they have exited from what? The UK, the EU, right? This is a recent decision that it will be interesting for you to read. But we too must, by the end of the day, leaving this conference, we must have a framework, an understanding whether or not trans people are covered under what we are thinking about or they are not covered. That is something we should ponder about. What is context of justice? Professors have gone through it, and I shouldn't belabor the point. And we have a lot of conventions and protocols who have dealt with that matter that I do not need to waste your time on that. But what is important is that what are the requirements of state parties? State parties are required to provide the requisite structures and instruments to protect women and to eliminate inequality, provide equity and all those things. That is what is required of us. Inhibitors of women's access to justice. The first I actually want to ask, these are rhetoric questions. You don't need to bother yourself answering them. Asked to begin with, can a man give what he doesn't have? Nemo that. You can't give what you don't have. You can't give what you don't have. Can a traditional leader deliver quality justice when he has no such competences or not been equipped with such competences? I just mentioned the fact that our judges and magistrates are engaged in continuous legal education. But sometimes they'll pass a judgment and so laughable. They say, aha, what is this one? This fundamental principle of law and you don't know. But that is the case. Is it the case that a traditional leader is one that will say, let's give a dog a bad name and hang it, so we'll go and rest? Or it is that the system is dysfunctional by itself, that they are the victim of circumstance? Anytime that our laws are not functioning, blame traditional leaders. Anything, blame traditional leaders. They are the ones who are frustrating it. Or is it the case that the system is just not just functioning properly? We would need to think about that. And do they actually contribute to our country? I will tell you on authority, and my respected chief is here to say that if you see that it's a peaceful country, they are holding the country, not the politician. If you left with the politicians, Ghana will burn within a day. with the greatest of respect. Our election petitions, the reason why it doesn't inflame is that it is the chiefs. When they call you and they tell you that the verdict has come, whether you believe you have won or you have lost, agree. You have to agree. If you don't agree, after that, when you come campaign again, they say, don't come to my community. When I spoke to you, you refused to listen. So chiefs are revered. Chief, 2020 election petition. John Dramani Mahama believed His Excellency, the current president, believed he had won. And rumors had it that he actually won because you realize they actually even had a number of parliamentary seats than the other party, the former party. But because of a lot of tussles here and there, they actually had almost equal numbers in parliament. It was a difficult thing for the current president to agree. But the chiefs called him and said, my brother, agree. Let's have a peaceful time. You have an opportunity to come again. By the grace of God, he has come. So as far as Ghana is concerned, the traditional justice system and governance is the foundation of the stability of our country. They are very important persons who ensure that the country is stable. And when they speak, you must listen. If you don't listen, your political career will end very soon. And I mentioned whether it is born out of their actions or inaction is born out of weakness or wickedness. Let's reflect about it. Is it half full or half empty? Whatever perspective that we give to it will bring about the interventions that would advance. But if we think that it's just wickedness, fine. You won't even listen to them. You give them the benefit of the doubt. But if you think that it's lack of what? The competent skills that they haven't been given, then interventions would also be given to them. I would not waste time to talk about patriarchy when it has been dealt with very competent people than myself. And we also spoke about another inhibitor is male-dominated traditional tribunals or courts that you go, and it has been dealt with already. African ADR mechanisms or conflict resolution mechanisms, it actually acts as a sword and a shield. There are sometimes you would go there because they say that Ujama. I don't know if I've gotten it right. Ujama. Because they say Ujama, it must die here. It won't go in front. That at that particular instance is a shield of perpetuating what? Wickedness and abuse. At some point, because of the community benefit, you the only bad person in the community, you can't destroy the name of the community, so you'll be dealt with. So it acts as a shield and a sword, and we have to actually look at it. Technical competencies is also very important, as we have mentioned about it. There's also the psychophysical, economic, and social barriers, limits women's ability to actually advance their courses. Legal aids has been discussed variously. Legal transplantation is what impacts negatively on us. How can you have a law which says that begging is an offense? Right? But you don't have a law which will say that people who are begging should be what? Picked from the street, put in a housing facility, educate them to become better people. Which one is better? It means you know the problem, you are not intending to resolve the problem, but you are just what? Making a legislation which is with the greatest of rights. It doesn't make sense. Begging is an offense. Begging, who begs? He's hungry. And most of the people who engage in begging, they are wearing tattered clothing. And some people have now mastered to use that as a trade, right? So they recruit people, 10 people to be begging. So when they beg, they take it. But if those young ones were taken into a facility and given better education, then begging would decline. So legal implantation actually affects us as African people when we take the law and we refuse to what? Contextualize it. So that is also an instance that when we find this law sometimes are very negative as far as that is concerned, women access to justice, and our plural legal system establishes what? Forum shopping. The gentleman goes to the chief first. He wants to test to know the value of his case. He goes there and chief says, no. This one you have abused the woman. it will go to court. If it goes to court, it's going to be so and so and so. He has tested and he has seen the weakness of his case. And he now prepares well for. Or he sees that, no, this matter, if I take it to the court, it will not work. Let me go to chief. Chief is good. Chief will solve this matter. It's a criminal offense, some misdemeanor. So let me go to chief. So because of those forums, it actually gives room for escape. That is very important that we have to look at. One way approach, our legal formalism. It is that disturbing and negotiating for gender outcome. There are even some places that men would have to go and actually advocate for you. Why should you go and talk for you? Don't have a mouth. But the man must follow you to the tribunal, right? To even speak on your behalf, to ask whether you can speak, to even guide you as to how to also speak in that particular setting of a tribunal that you don't actually know. And reproducing what you already know. I have mentioned of this thing. This thing I want to mention. This thing. Fear of retribution and recidivism. You are afraid that if you go and report your husband and they finish the matter and he comes back, you are dead. Which one is better? You are not also willing to drop the marriage. Society will laugh at you. That you can't even keep a marriage. We are talking, you are also talking. When women are talking, you are also talking. Are you a woman? Why did you come out of your marriage? Useless woman. Now, that alone is a fear. And the fact that if you also go back, they will deal well with you. You say, you reported me. I'm back. I'll deal well with you. And a lot of things, that alone is that bad. And representation has spoken about that. Lack of adequate funding, that has been dealt with. And the courts of Africa has had an opportunity to deal with these issues that I will not waste my time on. And on the primogeniture that has been discussed. And discrimination on retraining our daughters not to even marry or to sit at home to give birth for children, or early marriage and all those things. But the one which is most important for me is the last one, where I say also the High Court of what? In Ketat. I believe my friends from Kenya are better placed to pronounce the names for me. If I don't pronounce it well, please do forgive your brother. I do not intend to exhibit my ignorance. This Kenyan case had to do with what? Dealing with the question of what? The FGM that we have been talking about. And whether or not it was what? Something, a custom which is what? Permissible. And the courts were allowed enough to say that no, this is barbaric, this is not good. This must not be practiced. So when Prof was dealing and everybody has been talking about it, my mind goes to deconstruction. If you say that this is the case, they shouldn't do it. What is the impact within the society? Because it is practiced in the society. The men have it in their minds that women who only undertake such practices are virtuous women and are wife materials. Anybody who doesn't do that is not a wife material. So those who would force and do that are in demand. A lot of men will come. They have a choice to select the ones they want. The rest of you who haven't done that, you are outcasts in the society. So you struggle to actually get a husband. So you realize that the system is structured in a way that, yeah, there's a court decision. Good. But enforcement becomes an issue because the customary law lives in the society. And the people, you can't force them to change their mind that I will marry somebody who hasn't done FGM. I'm waiting for an FGM woman. So perhaps you will now find out in that society, those who will force and do it, if they are going to dowry, the dowry system will now rise for those who have done it. And those who have not done it, it will decline. Those are things we can investigate about. We'll come to look at ideas as to how to deal with that. There are some cases that we can look at. So I talk about enforcement and compliance. What is actually the state of the enforcement and compliance to these judgments which are issued out? It's no secret that our courts have pronounced very loudly some of these customary practices as not good and shouldn't be practiced. But why are they still there? It means there is a disconnect between the law and our indigenous African society or customary law, and we say that customary law lives in the society. And yesterday, Her Excellency was talking about internal effectiveness, or what the law says and what is actually practiced in society, and it was really interesting for me. And that is internal effectiveness and external effectiveness. Internal effectiveness, the law is there, the courts have interpreted upon it. Now go and enforce it. I'll tell a practical example. I had a session where I was teaching some people and mature students, and somebody gave that there was this property dispute when the man had passed away, his spousal property, and the wife was actually on it, fighting for the property. They said, leave this property. You. They said she will fight for it. But the woman had a son. And they said, you are still fighting for this property. Leave this property. You. And she's continued to fight. In no time, the son died. The son died. And they said, you see that your son has gone. Leave this property in peace. And she had to just abscond. Because if you have lost your son, know that the next thing is that you lose yourself. So the threat is bad. When it comes to what? Implementation, enforcement. The property is in a family land. Let's assume your husband has a property in the family land. You have gone to the court and you have judgment that it belongs to you now. The family have rejected you and said that you cannot occupy that property. You have judgment. Can you go and stay there? You have judgment. That's white paper. Go and enforce it. You have the property, you can't step your foot there. So that is the issue that women actually encounter. Why then do we need to harmonize? We need to understand that Africans, in the first place, we are very sociable people. That's a fact. That wherever we go, we are very sociable. We are very friendly. We are very helpful. Does that include our traditional leaders or not? That's a question. If we say that we are sociable, we are friendly, we are this, we are that, does that include our traditional leaders or not? Or they are the only people that when you come to the society, they are the tyrants, they are the dictators, they are the people. In fact, they are the leads that when a stranger comes to you and you are courageous enough, take them to the chief is happy and will do good to them. Are we now saying that we are general to people, friendly to other people, and wicked to ourselves? Something we should reflect about. So it means that we would need to identify the weak link. And I dare say that Europe, and there are still some of them are still practicing chieftaincy, not so? The UK, they are practicing chieftaincy. Is it not a monarchy? Is it not a chieftaincy? That's chieftaincy. Denmark is not chieftaincy. Spain is not chieftaincy. They are chieftaincies. We too are having chieftaincy. Why is it that we haven't seen anything good about our own? But they have been able to, manage to bring them together, to harmonize them, say that they operate seamlessly. There's order. There's beauty. So let's look at that. That should be the way forward. That should be, without that, we are going nowhere. And as I've mentioned, we have actually been able to, constitutionalize our chieftaincy and traditional systems. So it means they have something to offer. In the case of Ghana, chiefs have schools, chiefs have hospitals, chiefs are spearheaders of development in their communities and in their towns. Chiefs have funds and educational funding for vulnerable people in their communities. So the system, if it's well developed and harmonized properly, I think that will help. Now, in Ghana, we say, and now to the meat of today. How do we harmonize? The first is what Prof and the team have organized. Regional, sub-regional, state dialogue seminars and conferences. We are reflecting, we are thinking again of our previous state of being, our current state of being, and where we want to go. The dialogue is very important. How have we managed our systems as far as women access to justice are concerned? We are identifying the gaps, the clashes, and where we can go forward. It shouldn't limit here. We should have national dialogues, we should have sub-regional dialogues, so that we firm it up, so that there becomes what? There's an ownership to it. Not that, oh, they start somewhere in Arusha and discussed and took some tea and came out with this, and they've just dropped it on us to implement. Who are they? What do they think? What and what? And they will just dump it somewhere. It should be owned. They discuss it, they transform it, they contextualize it, and it can be implemented. Doc started by using the word deconstruction, and it was just exciting for me. I actually love the word deconstruction. Deconstruction is very important, since most of the time our escape route is to say that, oh, this is colonialism. Oh, this is a colonial thing. Oh, this is a colonial thing. If we claim that some of the things that are happening are legal implantation, colonialism, then deconstruction is the way forward. We need to deconstruct what do we mean by women access to justice. If we think that that definition is not actually even understandable to the common man in our societies, how would we deconstruct it that in your community, someone who is an illiterate understands women's access to justice? Somebody who hasn't been to school, when he hears, he should understand. We would need to know about that. Homegrown, in our own way, in our own terms, how we understand it. It must be broken down. Law, what is law? My little understanding of law is a tool for regulating society. So if it is a tool for regulating society, and traditional justice system requires that traditional leaders and within our indigenous societies actually regulate the society, then they should understand. So localizing legal education relevant to what? Traditional leaders in their own native language. That is something that must be done. If we want to achieve what we are saying, you should be able to simplify the criminal law of Tanzania in Swahili to them, so that they understand what is pertinent and significant as far as women access to justice is concerned. So if you go to Ngorongoro and you organize a session, it should be in their language. Cite cases in their language. What the court said. And you will see how intelligent they are and would contribute. And that they will testify. But if you go and say, Criminal Act so and so says this, and says this, and you are quoting convention so and so, what has convention so and so to do with what? Who knows what? Some of the things that we say, if you understand ourselves. If you don't understand, you begin to mention big words, right? So that's the escape route, right? The next thing is that we have to ensure that there's effective legal and policy reforms. Internal effectiveness, external effectiveness. It must be effective in the law and effective in practice and implementation. Special community-based dispute resolution mechanisms are very important. We have identified an issue. The issue is that there are abuses. Then there should be a direct policy intervention on that. The communities know, after you have trained them and said it's a system that we are establishing, which you are part, that it deals with this and that. Okay, I have been prompted. So I have balanced native courts, we have Queen Mother's tribunals, we have ascertainment documentations, which are known, codification, recording of judgments. Sometimes we complain about the fact that they are getting it wrong. Traditional leaders are getting it wrong. What is your source and basis? Do you have evidence to that? Once in a blue, you hear that a traditional leader has done so and so. Do you have evidence to the many judgments that they have done for you to review and to, train them on? That is something we should look at. Legal staff, women lawyers can contribute, special courts, And I am recommending that special courts should be established. Just as we have commercial courts, land courts, we should also have that. Legal aid and psychosocial aids have been spoken about, capacity building, and we talk about sensitization, enhanced approach to making the laws. And I talk about payment of traditional leaders realistically. Pay them. Judges, you are paid. And I'll make an argument that the number of cases that our traditional leaders resolve in a month are more than what our judges resolve in a year. Yes, I tell you. Because by the second, they resolve matters. Some of them that come to choke your courts that you complain about, so they should be paid realistically, not that you give them peanuts. And the last but not the least, we have the Lagos multi-door, right? We have Lagos multi-door. Ghana, we call it the court-connected ADR. And others we call it the ADR annex or something like that. It should be enhanced, where women should also be central in dealing with the issue. And this is me undertaking empowerment of women. And these are queen mothers. They are queen mothers from various communities. And they do, and they try, and they try to resolve matters. What they're actually doing, they are resolving matters like that. Everybody is there. And they were doing it in the presence of men. In fact, the women were doing it much better. And the men were excited. The women were doing it better. And the men were also doing it better. And we had so this is actually queen mothers also in different regions. So there are different regions of our country like that. And the woman that you see that there's the highlight on her, she calls me. I am somewhere and she calls me. And she tells me that there's an issue in their area. I said, what is it? He said, there's this man who's a pedophilia. She has been destroying and defiling young girls and all those things. I said, you have to fight this. He said, but the chiefs. And I said, oh, have you gone to the chief? He said, no. I said, go to your chief. Tell the chief that this is what is happening and this is what we need to do. And I told her, she spoke to the chief. We drafted some letters. We did some advocacy. And within the spare of the moment, the next day, that particular region, all the radio stations were beeping with that particular matter. In no time, the gentleman was arrested. In no time, the prosecution was fast-tracked. In no time, the guy has been jailed. In Ghana, if you are a man, do mistake and molest the woman and goes out of social media, the Minister of Gender will come for you. The Attorney General will come for you. It's not something, you yourself, you are afraid. If you dream, you are in trouble. So women, as far as the public acceptance of women's rights, it is something that I think that the society to take. I'm most grateful for the opportunity.
Well done, Mr. Peter. It was inspiring. But at the same time, I think you have raised at some point more questions than answers in my mind, and I believe in the minds of participants, especially with regards to that question of LGBTs and who is a woman. And you reminded me actually that yesterday, indeed, that question was not answered. And I'm going to yell at my brother, Judge Chikaya, to send us the answer. But since we are visiting the African Court on Human and People's Rights tomorrow, if you realize that forgetting to remind them to answer the question. Please.
I'm most grateful.
Yeah, they have to answer. But on the other side, I think you impliedly called upon the African Institute of International Law to organize more sessions. I mean, to discuss on LGBTs on the African continent. It's not easy, though. Don't go to report me, please. It's not easy, I mean, and I get trouble when I'm teaching and my students to raise this question. Where do I start and how am I going to behave if I start? You know, so we have to do something, and we have to do it together, because it's like we are walking on eggs. You know, when we are walking on eggs, you have to be very careful, and you understand what I mean. Without much ado, ladies and gentlemen, join our hands to welcome Ms. Jacinda Peter for her presentation. You are most welcome. You have the choice to present seated or standing. We are in a free and democratic society. Welcome.
Thank you so much, Professor, for the welcoming remarks. As is preparing my presentation, good afternoon, everybody. As Professor has introduced, my name's Jacinda Peter from the National Prosecution Service. I am the Principal State Attorney, and if you allow me, I would love to do my presentation while seated. My role this afternoon is to present prosecutorial strategies and challenges in handling GBV cases, emphasizing coordination with victim support mechanism. Yeah, so my presentation is based on the GBV cases. And in my presentation, I will talk or discuss about prosecutorial strategies and challenges in handling GBV cases in Tanzania, emphasizing coordination with victim support mechanism. And my presentation will cover subtopics as you have seen there. And to start with the definition of gender-based violence, it is a wide phenomenon, but in simple terms, it means the harmful act of violence, including physical, sexual, psychological, and economic harm directed at an individual based on that individual's gender, or violence that affects persons on a particular gender disproportionately. And also, gender-based violence involves both men or boys and women or girls, but most vulnerable group is women or girls. Now, the second part that talks about impact of gender-based violence. Throughout Tanzania, gender-based violence is widely spread, like in any other countries, as we have been talking, and it has caused severe impacts, mostly to women and girls physically, psychologically or mentally, health or emotionally, social, economically, and culturally. It is also a major public health concern, but also equality and human rights concern. Excuse me. Now, when we talk of forms of gender-based violence, gender-based violence occurs throughout lifestyle, from prenatal phase through childhood and adolescence, the reproductive years, as well as old age in both men, women, boys, and girls. And it can be in many forms, and it has effect to individuals physically, psychologically, emotionally, and economically. Okay, thank you. The forms includes the gender-based violence forms include sexual violence. This is any sexual act or attempt to obtain sexual act through use of force, coercion, threat, or use of force, example rape, including marital rape, attempted rape, or sexual assault, defilement, sexual violence. Thank you. This is better. Sexual violence against minors, sexual harassment, or unwanted touching, comments, or advances, forced prostitution or sexual exploitation, forced pregnancy or sterilization. In terms of physical violence, it can be any act causing psychological harm or torture to an individual, such as harassment, coercion, verbal insult, or defamation. And in physical violence, it can be any unlawful act or physical force which causes physical harm performed on an individual, such as deprivation of liberty, serious, as well as minor assault and manslaughter. In the context of economic violence, it's any act or behavior which causes economic harm to an individual, such as restricting access to financial resources, education, or labor markets, or not complying with economic responsibilities like financial support and property damage. Now, the main focus of my presentation is the prosecution part, the challenges and the strategies. So, in Tanzania, prosecution of criminal cases is vested in the Office of Director of Public Prosecutions as the sole institution with authority under Article 59, capital B, of the Constitution of the United Republic of Tanzania, 1997, as amended, to conduct, control, and prosecute criminal cases on behalf of the government of the United Republic of Tanzania. And in quotation of the article, the Director of Public Prosecution shall have the power to institute. He has the power to institute, to prosecute, and supervise all criminal matters in the country. Now, the function of the DPP's office related to prosecution of cases are daily carried out by the National Prosecution Service, as is stipulated by the National Prosecution Act, revised edition of 2023, where I work. And in quotation, the section 9 of the Act states, the Director of Public Prosecutions have the power and function of to decide or not to prosecute in relation to any offense, undertake any criminal cases on behalf of sovereign of the United Republic of Tanzania. Now, these are the powers of the National Prosecution Service under the directorship of the DPP in prosecution of criminal matters, where gender-based violence is also inclusive. Now, in dealing or handling gender-based violences, we have encountered several challenges that I'm going to highlight as follows. The first one is the victim age and vulnerability. When we do prosecution of these cases, of gender-based violence cases, we encounter challenges like this, whereby victim children may be too young to understand or articulate what happened to them. Hence, they fail to explain how to testify accordingly in court, leading to unsuccessful prosecution. Also, there are times in our law, it is settled principle that true evidence comes from the victim of cases like rape or sexual offenses cases, so long as the court finds it credible, the person or the victim testimony is credible, then the court will rely on it and convict the perpetrator accordingly, just by the evidence of that witness. And this has been enshrined in the case of Selemani Makumba versus Republic. It's a Tanzania reported case of 2006 on page 376. In this case, this is what the Court of Appeal ruled, that even a sole testimony of a credible victim witness of sexual offense can warrant conviction. Also, this also is in the section of the laws, which is section 135, subsection 6 of Tanzania Evidence Act, which is CAPU 6, revised edition of 2023. It empowers the victim to give their testimony even without collaboration, evidence from adults, despite and now this is the position, but despite being so, the victim still can't speak in the courts, and this makes the prosecution case fail. There are scenarios where the victims may be easily intimidated or manipulated by accused or accused relatives or others. And victims may be too young to remember the perpetrator, the time, and also the place of incidents. When the prosecutor is deciding of the case, we have to put the particulars of the offense very clear, touching areas of time, when the offense occurred, at what place, and on what dates. If these things are not there, then it's hard for the prosecutor to frame a proper charge. Another challenge that we encounter in our day-to-day prosecution of GBV cases is reluctance or fear to testify. This is because the victim's fear of reprisal or community blame or further harm, especially in domestic or incest cases. Also, in the circumstance when the victim is pregnant and they tend not to testify against the perpetrator, or for the reason that if the perpetrator is going to be convicted and sentenced to jail and she's going to deliver the baby, then who is going to be the father of that baby, or who is going to take care of the baby? So they fear not to testify. Also, some of the victims fear shame or guilty particularly in sexual abuse cases, due to fear of being laughed at or community isolation. And there are some adults, in certain cases, they compromise with the accused in the context of love affairs, thus unwilling to testify against the accused because they will lose the benefits attached to the abuse. And there are times emotional trauma make it difficult for them to recount events. Another challenge is the lack of corroborative evidence. Crimes like sexual abuse often lack physical evidence since they are not committed in public areas. Also, delayed reporting may result in loss of forensic proof as required by the law under Section 8 of the Criminal Procedure Act, CAP 20, revised edition of 2023. And this has been observed in the case of Director of Public Prosecutions versus Simon Mashauri. It's a criminal appeal, number 394 of 2017. In this case, it was an appeal case before the Court of Appeal, and we look because in the evidence, the victim could not did not report the matter immediately, so there was loss of forensic evidences, and this is because of the lack of knowledge or lack of technical know-how, that if you report early, there are some evidence that we are going to have which will be helpful in the case in the future. And there are times there are no eyewitnesses, making heavily reliance to the victim's testimony. In sexual offenses, mostly there are no eyewitness. It's only the victim and the perpetrator. And we have cases where imbecile victims are being violated, and they cannot testify before the courts, and we end up losing the cases. We have other challenges where the legal and procedural hurdles also prove as hindrance in us to prosecute the cases successfully. For instance, in the rule of evidence, where a child is involved in giving their testimony before the court, and the rules like cross-examination can be traumatized. They have gone through trauma, and then they have to explain it over and over again. And some of the questions in the cross-examination, lawyers will agree with me, are very traumatized, and they have to answer. They have no choice. Also, lack of witness protection mechanism due to lack of funding, thus victims remain vulnerable to intimidation, coercion, and other form of undue influence, thereby undermine the integrity of the judicial process. We don't have the funding to help the victim in the manner in protecting them before they give their testimonies or even after. We have had encounters where in the GBV cases trials, some medical or health practitioners filing police medical examination forms, OPF3 forms, or post-mortem reports tend to give contradictory testimonies, legal findings instead of medical findings. And some of them conclude the commission of the offense instead of giving their medical opinion only. So when they do this, their testimonies are jeopardizing our case. What the court expect from them is to give their medical opinion. And also, there are cases where medical and health practitioners fill police medical examination forms, OPF3 forms, or postmortem reports, while they have not renewed their practicing certificates under the Medical Council of Tanganyika, which is the mandatory requirement. As a result, their testimony and exhibits from the court's records are expunged. The law of the child make it mandatory for the children not to be punished by jail or any other form, but only conditional discharge. Now, this is failing in disciplining the children, and then they make them habitual offenders in most cases. And also we have encounters where a child of 15 years is married under the parent consent under section 13 of the Law of Marriage Act, which is KEP 29, revised edition of 2023, but this one is in conflict with section 3 of the Law of the Child Act, KEP 13, revised edition of 2023, which recognizes a child as a person under the age of 18, and any person marrying a child under the age of 18 can be charged for statutory rape. So we have these conflicting sections of the law. Other scenarios includes when the victim forged their age to be of majority for marriage due to their body appearance. There are some victims who appear to have, they want to get married because of their body, and they have to forge the age so that they can get married. Also, there are times accused persons are most of the times, or we feel this, that accused persons are more privileged than victims in most cases in the compensation way, because in the magistrate or the judge will always give compensation based on the financial capability of the accused person. And this, to us, we feel that the accused persons are more privileged than the victim of the GBV cases. The point of social and cultural barriers. Here, there are stigma around sexual abuse, and this is preventing many victims not to report. There is also the issue of family pressure to withdraw complaints, especially in incest or community-related cases. Myth and beliefs like children lie or exaggerate. Parents or guardian forcing accused to be charged according to his or her wishes, contrary to the evidence available in the file. You'll find a parent or a guardian of a victim of gender-based violence case wanting you, the prosecutor, to charge differently from what you are reading from the file. This is very challenging to us, and they really don't understand if you do otherwise. Witchcraft beliefs led some people to commit gender-based violence also. Another challenge is the lack of specialized support systems. We have few child-trained psychologists or social workers to support victims, inadequate shelter or protection mechanism for vulnerable children, delay in forensic examination or lack of child-specific forensic services. And in most cases, we face challenge in court prolonged proceedings, which are very traumatized to the victim of gender-based violence. Because when you take a child for when the child was abused, they were very young, but by the time the case is finalized, now they have attained the age of majority. So this is also a challenge. Now, what is the best practice that we are employing or we are using to cater the challenges? What are the strategies that the National Prosecution Service is using? Includes use of child-friendly procedures like video testimonies or in-camera trials, specialized training for prosecutors, judges, and law enforcement in handling GBV cases. We also have multi-agency collaboration with social welfare, health police, and prosecutors, lawyers, and as well as judicial officers. Sometimes we get funds from NGOs and we do witness protection. Like there is a very recent case in Dodoma where the NGO facilitated the witness protection and the case was successful. And also psychosocial support services. We also encourage shared resources among stakeholders to handle GBV cases like the way I've mentioned. We got help from a certain NGO to assist us with the protection of a witness, and we emerged successful. We also use safe house or change of residence to fit persons until the completion of the case, especially in situations where a victim has been abused by a parent, trusted people, or close relative whom they live with and they cannot be free due to intimidation. Also, we use victim testify on the first day of the registration of the case. In most GBV cases, the victim always tended to compromise and they will never come to testify when the case takes long. So nowadays, when we file the case and we go to court, the same day the victim will give their testimony. Also, we have community empowerment to abstain from witchcraft beliefs. We do this through other stakeholders also. We also have legal reforms to strengthen child protection mechanisms. We do the establishment of special child protection units and fast-track courts. We also have capacity building training to stakeholders in the justice system, public awareness and community involvement, as well as monitoring of juvenile courts, whether they are performing their roles in compliance with the applicable laws. Now, this is what we recommend, that training to medical and health practitioners on how to fill in PF3 and post-mortem reports should be ongoing, because we are doing this, but we should remind them over and over so that we don't get trouble in that area. We also liaison with medical or health practitioners in charge to remind them renew their medical practicing licenses. And also we do fast tracking of GBV cases investigation as well as prosecution. And in conclusion, we reaffirm the duty to protect children. We call for a coordinated, right-based approach to child justice. We employ the importance of balancing justice for victims with safeguards of the accused. And also, national prosecution will continue to work in collaboration with the African Institute of International Law, stakeholders, civil society organizations, and other service providers to ensure protection of GBV cases survivors.
Thank you very much, Ms. Senator Peter. And I'm very happy that the DPP office is ready to work with the African Institute of International Law. There are indeed many areas on which we can provide capacity building to the prosecutors in this area. Ladies and gentlemen, we have now time for questions and answers. Let's try to be as brief and concise as possible. And it's after this session that we're going to have our lunch. The floor is open.
Thank you so much, our last presenter, for insightful discussion and very, you've made very many strides that we shall. About age, you spoke about the consent of parents. I think in allowing marriages of children, I didn't get quite that. But then about what mechanisms do you have in determining age for children? Because we have in Uganda situations whereby cases go for capital offenses, but the age of the child was not determined at the inception of the crime. So by the time, because our prosecution. So because we don't fast track, 2 years down the road when someone has spent time in remand, it is discovered by the judge that actually they were underage, maybe they were 16, and yet they have been remanded in adult prisons. So I just wanted to, if you could shed light on how age is determined so that you can be able to isolate the benefits that apply to children who have committed maybe sexual-related offenses, how they can benefit from those privileges that are in the children laws. Thank you.
Thank you. D'accord. Merci aux différents présentateurs. Merci pour votre brillante présentation. J'ai beaucoup aimé. Mais j'ai une question par rapport à l'intervention de Monsieur Peter. De Monsieur Peter, voilà, je vais m'arrêter là. Voilà, de Monsieur Peter, par rapport aux tribunaux communautaires, voilà, aux tribunaux traditionnels. Et ma question est la suivante. Est-ce que vous pensez que lorsque les femmes amènent leurs problèmes devant ces tribunaux traditionnels, est-ce qu'elles auront la même solution si elles amenaient ce problème-là devant les tribunaux modernes? Voilà. Parce que devant les traditions, la femme n'a pas assez de poids. Donc, la justice qui sera rendue devant les tribunaux traditionnels ne sera pas aussi, comment dirais-je, en faveur de la femme. Bon, je suis chargée de l'assistance juridique des femmes. J'ai vu des femmes qui ont été obligées de saisir les tribunaux modernes parce que devant les tribunaux traditionnels, vraiment la solution qui a été donnée, ça montrait clairement qu'il y avait une injustice. Voilà. Donc, c'est là ma question. Merci bien.
Thank you. I request for your clarification on the point of witchcraft and how it affects the prosecution of these cases we are talking about. And my next question is to Dr. Kahina Imam. I know that the Quran in Surah 4, verse 34, says that as for those women from whom you fear defiance, admonish them, leave them alone in their beds, and beat them lightly. And I was also appreciative of your clarification, because I thought that the hadith is a very, very authentic in its entirety. So I appreciate that you clarified that. Thank you.
Thank you very much for the presentations. I also have a question for Dr. Balloul, Imam Balloul. So Islamic feminist groups who use the interpretation of Islamic texts in order to advance women's rights are often criticized for being part of a kind of what's called an imperialist project, because they're using the same liberal democratic language that's often used to justify efforts to supposedly save Muslim women. And so I wonder if you might share your thoughts on how you see these critiques and how you think Islamic women's groups might respond to them.
Thank you. It's working. It's working? Oh, sorry, I didn't hear myself. Okay, thank you very much for the insightful presentation that you have done. I have a question for Mr. Peter. Actually, from my understanding of traditional justice system, the heart of this system is to ensure that people are living in harmony with each other in the same society. This is my understanding, and correct me if I'm wrong. And you said that the system exists and will exist, but the thing is, it will change, but it will never disappear. The question is, as it is changing with time, what are the changes that have been, that you have witnessed or it does exist in favor of women's rights? That's it. Thank you.
Yes, good afternoon, everyone. My name is Nuru Kenja from University of Dodoma. I have a question to Ms. Jacinta and another question to Dr. Kahina. First of all, I'll start with the question to Ms. Jacinta. So I would ask, not having a specific law which provides for women's rights in Tanzania, because we have various laws like Penal Code, SOSPA, Law of Marriage Act, and others. Not having a specific law, does that impact in prosecution and having a lot of cases in gender-based violence? And also another question is, how do you deal with technological facilitated violence in Tanzania? Because right now there is a big issue in technological facilitated violence to women. Now, how do you deal with it? And Tanzania laws, we have Cyber Crimes Act, but is it sufficient in prosecuting such cases? And to Dr. Kahina, I wanted to ask, it is a belief that the Quran is not tampered with, that because of its preservation, we believe that it's not tampered with compared to other religious books. Now, how can we make sure that the hadith, which are not actually authentic hadith, are not circulated, leading to misinterpretation and also leading to gender-based violence? Thank you.
Hello. Yes. Oh, sorry. Okay. Hello, everyone. Thank you so much for your presentations. I'm here. I have one comment and one question. So my first comment to Dr. Kahina. What your presentation is extremely important, and I think it can be a complementary to the work of Musawa movement for equality in the Muslim family, because they are doing the same things that you are doing, but they are also producing in multiple languages. They are also producing interpretations of the Quran, of, as my sister said here, how we can check whether or not these kind of hadith are authentic or not. This kind of production and knowledge production is important for us as Muslim women, as Christian women, whatever religion we are, or whatever we believe in, but the fact that we have the knowledge, since they are, I mean, the conservative groups are bringing religion into the public sphere, then they have to stand that we are discussing religion in the public sphere as well. It goes both ways. So this is my first comment. The second comment, my second question is to Mr. Peter. So I love what you did with explaining how traditional courts or the traditional justice system is doing. I just have the same question that in my mind, because I believe justice does not mean that we need to follow authority all the time, okay? Because justice is justice. But the thing is, how can we ensure justice? What is justice? That is a very philosophical question. But how can we ensure that justice and equality are served correctly without the interference of the state, if the state is not there through the traditional courts? And if the state is there, how, as activists, as people from academia, as lawyers, how can we also push for the rule of law if we have what we can call a quasi-justice system or a semi-justice system? Because this, I mean, I don't have an answer, and I'm interested to hearing your perspective on that, because I believe that justice, it's extremely, at the current moment, it's a fragile, really a fragile context and a fragile definition, because in each community might have a certain definition of justice, but in the core, it might not be just at all, and they are discriminating against women, girls, and all other people. So I want to hear your perspective on that. Thank you so much.
Let me use this medium to thank all the presenters. Thank you so much for that wonderful session. So I have two questions, one to Dr. Balu and the other to Mr. Oni. So I really love the analysis and the fact. In fact, I would say, despite being a Muslim, this was the first time I really heard so much about unauthentic hadith. So in the light of this, do you think, and like my sister has said, that it's a relief that the Quran has not been tampered with? But when we look at the way these religious texts, both the Hadith and the Quran, are being used, especially by religious leaders, to promote, support, or perpetrate violence, especially against women, would you think it is important to now codify the authentic hadith? And then, even within the authentic hadith, if there are conflicts, if there is a direct conflict with the Quran, how do we go about resolving that? Especially when they say you must go with both. So I guess that is my question for you. Mr. Oni, this is really interesting. And like I said yesterday, it's a relief to see that my neighbor, Ghana, don't worry, this is not jollof rice, that they're doing so well in trying to bring the traditional leaders within the fold of legal framework. Now, the challenge for me is when you talk about who is a woman, in the absence of a legal definition in Africa and some parts of the world, would you say we go with what the UK has done? Because if you look at the biological makeup, I think under the constitutional provisions, especially an international instrument that talk about the fact that there shall be no discrimination based on sex. And when we look at the scientific definition of sex, it has to do with your biological makeup. Would you now say, in trying to conceptualize sex now in in light of modern realities, we should go beyond biological makeup and then consider gender identity. Remember, when defining sex, it's not about gender, it is about biological makeup. So I can still answer that question, but now this is where the confusion may be. For those that identify as women and that have taken steps, or maybe the trans people that have taken steps to actually have the surgery to transform their biological makeup, in trying to come about a legal definition for men and women in Africa, do you think this is going to be a great influencing factor? Thank you.
Thank you.
Merci beaucoup.
Okay. Thank you. My name is Veronica John. Okay. Can I continue?
Okay.
Yeah.
Oui.
Okay.
Je peux? Ok.
Thank you. Thank you. My name is Veronica John, advocate from Kigoma region. I have a question to my friend sister, Jacinta Peter. Jacinta, I would like you to know, to understand, how does the National Prosecution Service apply a survivor-centered approach in handling GBV cases in court, at the same time manage to balance between the legal frameworks and the human rights instruments to ensure effectiveness in the prosecution service of the GBV cases. Thank you.
Merci beaucoup. Amy, je suis avocat expert VBG. Ma première question. C'est Peter. Je voulais savoir quelle implication. Quelle est le. Oui, je m'adresse à M. Peter et je voulais savoir quel est le degré d'implication active des leaders communautaires et dans la lutte contre les violences basées sur le genre. Quelles sont les évolutions, s'il y en a, et quelles sont les barrières? Et ma deuxième question, ça s'adresse à l'islamologue. Et parce que je lui ai écouté en train de parler par rapport à la recherche de la religion musulmane. Et je voulais savoir quels sont les outils et la méthodologie que vous avez utilisée pour arriver à vos différentes conclusions selon lesquelles la religion musulmane aurait des évolutions significatives par rapport à la lutte contre les violences basées sur le genre. Quels sont les outils que vous avez utilisés et quelle est la méthodologie que vous avez mise en place, et au-delà de ça, quelle est l'approche méthodologique pour arriver à cette conclusion? Et vous avez évoqué un aspect selon lequel la religion musulmane aurait des défis et des contraintes dans la lutte contre les violences basées sur le genre. Ma question est de savoir, pour arriver à cette conclusion, quels sont les outils et l'approche méthodologique que vous avez utilisée. Ma troisième question, ça s'adresse à... Oh là là, sorry, j'oublie les noms. À Madame Jacinta, à Madame la Tanzanienne. Madame Jacinta. Si je prononce bien, bon, prière m'en excuser. Et je voulais savoir quel est votre regard critique par rapport à la gestion des cas. La gestion des cas et des violences basées sur le genre. quel est votre regard critique comme activiste et quel est votre regard critique par rapport à la gestion des cas de violences basées sur le genre et quelles sont les voies de sortie pour y parvenir. Merci.
Thank you. Thank you very much. My question goes direct to Peter. I was very much interested when you were presenting about the chiefdom, I can say, the way your community is organized through chiefs. But at a point, I was disappointed to hear that the chief can commit any criminal issue, and it is impossible even to hold him accountable to what he has committed. So, So I was asking myself that are the chiefs above the law of the nation? Okay. If the community, that's, you're saying that the chief can have its own community and you cannot go there without his permission and what. Is that community part of the nation? When it comes the issue of nation, that is Ghana, and the Ghana, it has its own law that is governing Ghana. So I was very much interested to hear from you as to whether these communities are part of the nation and whether the chiefs are above the law of the nation. Thank you very much.
S'il vous plaît, il y a une autre question.
Thank you. I think we give the floor to the presenters to provide the answers, perhaps very briefly, because as I can see, a number of people are hungry. And regarding the questions addressed to Peter, I think perhaps His Royal Highness will come to take the floor in another session, which is speak to his topic. Some of these questions, I believe, can be put on to him. The floor is yours. I don't know who.
Okay, thank you very much for the beautiful questions. And it's exciting to start from the bottom. Every community in Ghana is part of Ghana. And chiefs are not above the law. But the political context in which they find themselves, sometimes those offenses that we are talking about, which comes to them, they are able, sometimes you are unable to prosecute them because of the sensitive nature. They are minimal. So since they are minimal, they are able to have their way. Some traditional societies. Why do they have so much power? In Ghana, the chief is the owner of the people. All of them in his traditional area. So whatever he says, they will listen to him because they call him their father. And if any outsider or a politician, you disrespect their father, they will disrespect you. So if he gives word that you have come to the community, you haven't come to greet him, and you are organizing programs, he will tell them not to attend. It's because you have disrespected, that's their dignity. The chief is the symbol of their dignity and their worth. So if you disrespect the chief, you have disrespected it. That's how much they hold so much power. My chief, who is here, if you disrespect him, and you are even the president, and you come, we will not come there. we respect the chief more than the president, because you have only 4 years to go. You have 4 years to go. And what he does for us, you can never do. Our chiefs do not lie. What he can do, he will do. What he cannot do, he will tell you he cannot do. He lobbies and he works with various presidents before you. You would go. Other presidents will come. You are transient. So our chiefs are, the Chieftaincy Act makes them, if you are actually a chief who has committed an offense, you are not qualified to be a chief in Ghana. If you have committed an offense before, you are barred from being a chief. So chiefs even fear to commit offenses. You are stopped from being a chief in Ghana. So we have the laws would provide, the ethics are there. So hardly would you even find a chief committing an offense. Hardly would you find a chief trying to. So it is once in a blue moon. So when you hear something, it is something that we haven't seen. So everybody would rush at it. So, but the thing is that because some of the chiefs are found in the hinterlands where courts may be distant, and because we don't have law report that I'm requesting, if there were reports we can see, or small drafts of judgments, you can actually review them to know what they are doing. But there's the suspicion that they may be encountering or doing things which are unlawful. And that one, in my engagements with them, sometimes I give them sample cases to deal with, and intentionally I'll give them theft cases, right? And about animals and stuff like that, and they will resolve them, right? So at that part, but the law says that if it is theft, it's for the courts to deal with. But it's but it's just a cow. This is just it shouldn't go for prosecutions. Maybe this is just a fowl. This is just some bag of rice or something. But that is within the realm that they don't have the mandate to deal with. So our chiefs are accountable. Chiefs are not above the law. In fact, they are the custodian of our customs and our laws. And if you are a chief, and the moment you are a chief and you have been sentenced, you have lost your chieftaincy in Ghana. If they sentence you, you are no longer a chief. If you are a prince and by mistake you are arrested and sentenced, even if it's one day, you are not qualified to be a chief again. So they are very careful in breaking the law. Now, I go to degree of implication, question coming from degree of implication and importance of the traditional leaders as far as gender-based violence are concerned and the justice system. Because our customs lives with them. They are the custodians of our culture. And most of the times when something happens within the indigenous community, who do we report first? Your mother, your father, your head of family. And your head of family within the lowest levels of our societies is part of the decision making at the chief's palace. So he will now take the matter to the chief's palace. So they are part and parcel of everything. If you are going to do the decision making, he might be there listening to the proceedings and may even be called upon to give advice. So that is where the decisions are made. That is where the judgments or verdicts are given. And that is where whatever the punishment would be sentenced. So they are very important as far as dealing with it. If there's also a law from the former system and you don't educate them, empower them to know their legal mandate, they will continue to be doing the wrong things, which might be founded from their customary law. But legislations have been passed that female genital mutilation is an offense. But he doesn't know. He lives somewhere which is far away from any court's and police audience, knowing what they are actually doing. So they think they are doing the right thing. The society also knows that is the right thing, and that is the punishment. Who is a woman? That's an exciting question thrown back at me. Prof has clandestinely brought the question I'm seeking an answer to say that I'm not an empty head. What are you thinking? This is what I'm thinking. I'm thinking that Africa is growing, and when I used to have a limited mind about LGBTQ, but I reflected about it and I have a broad perspective to LGBTQ now. In Ghana, the current government benefited from LGBT campaigning and have gotten super majority, more than 1/3 majority in parliament now, because the former government were not bold enough to ensure that there was a law banning LGBT in Ghana. So in Ghana, when our customs are so firm that it is not something you want to talk about. It's something that the society has agreed and come to a conclusion. All the researches point to one fact that Ghanaians do not hate persons who are LGBTQ, but Ghanaians do not tolerate the practice or legalization of LGBT. So if somebody is an LGBT person, you cannot practice it, but if the person is victimized, the law will come after you. The law hasn't empowered anybody to victimize an LGBTQ person. The law has not given any empowerment to any advocacy of LGBT. The law will come after you. Anything that you do to promote it, the law will come after you. But persons who are already involved, the law that is about to pass would provide them with medical care, psychosocial support, and all those things. So that is how Ghanaians think about it. Whether it is subjective, so we should look broadly from the AU level, from the regional, sub-regional level, it should be broad. But coming down, it must be what? Contextualized, because it is the people. If the people do not agree and you make such a law, you are causing disaster and chaos in your country. So country one may come to terms with it. They don't have any challenges with it. It can be broad-based. Country two, you know that when you dare just do that thing, they are going to kill people, and in fact, innocent people. And you may not know whether your sibling is involved or not. That is what broadened my mind, because you trust yourself, but you can't trust another person. We have a proverb which you say that the hen can only defend or trust the egg, but not the chicks. Because the chicks roam around. So you can't actually defend the chick that, oh, it didn't actually eat your millet or something like that. But as for the egg, it is here. You can see it. So we shouldn't move far. It can be at the AU level, it can be broad-based. A woman can be a person who identifies as a man who identifies as a woman based on gender transformation. He identifies. And biological, it should be broad-based so that it's flexible. It's flexible. So countries who are specific are covered. Countries which are broad-based are covered. That is where I would think about it. But if we make it specific that it's only biological, then we would need to have another meeting to review it again. But if we make it broad-based, it is, and as usual, we are able to contextualize it. That will help us to handle that particular issue. As far as whether women would get justice, whether women will get justice when they appear before our traditional courts, which are male-dominated, I made a recommendation that there should be a balanced tribunal now, where some women who are queen mothers are made to be part on women issues, because there were that much and I didn't actually explain them, that it will be a balanced tribunal. But most of the time when women issues come, you realize that the chiefs would actually have women and queen mothers and elderly women that they confer with before a verdict is passed. But I think that if we have some other women who are part of the tribunal, that would also help to resolve that particular matter. There's also a recommendation for women tribunals. So the queen mothers that were trained are actually trained in what? Resolving disputes within their traditional area. So you have the chiefs and the men chiefs dealing with some issues and the women chiefs dealing with some issues. So sometimes when the matters go to the men chiefs, they refer to the women to handle this matter. So there are jurisdiction demarcated within that landscape. So we have queen mothers well established in various traditional areas in Ghana, even though there's a lot of room for improvement because of capacity and all those things. So that also helps. So if it's well developed and the jurisdiction are well designated, issues can be, and maybe at those instances, we can actually get some bit of justice. And that takes me to establishing Queen Mother. I've explained. If I happen not to answer your question, you kindly draw my attention. The last that I will be brief about is what is justice and equality in the face of our traditional justice system. What is my definition? What do I see? Justice is specific. Justice is specific to a community. What the people define as justice, that is their justice. What you may think is different, but your community is just a microorganism within the macroorganism called a country, like you were drawing our attention. So your justice in your community must be in tandem with the national system. So how would I know that what I'm doing is not just? Only when I have capacity, when I am trained, when the traditional councils or the chiefs in the local village is actually trained in his local language, in his own understanding, and the philosophy and theoretical principles brought low to his understanding to justify why he shouldn't be doing what he's doing. That he sees the reason that justice that he thinks is justice is actually unjust. And when you throw it back to him, if it was your daughter, if it was your sister, if it was your mother, it was your auntie, how would you feel? At that particular point, it is role reversal. Take it and see. Put yourself in the same shoe. He comes to the realization that, no, this is not actually justice. If it is about someone, it doesn't matter. But mostly if it is about you yourself, you realize, no, this one will not forgive. So I think that when we reflect about that, it will help us. But communal justice or our traditional justice system is no justice when it doesn't conform with the national justice standard. And we all know what our national legal systems provide as far as rule of law, democracy, and all those principles are concerned. So they must be apt to meet that particular measure. And we're actually here because we know that in our communities, they are not up to that level and must be brought up. But if they are not exposed in their own language and competencies brought up, they would not agree. And because they are that powerful and in some corner that in some darkness, most of them practicing what they know best, they will continue to perpetuate it. If I haven't answered your question, you may well prompt me. Thank you.
I will go straight to the questions posed. The first one was about how do we determine the age and what mechanisms do we use? In our court systems, we use birth certificates, and it's acceptable in the courts, and we take this. If they are not birth certificates, we use parent testimonies, and also doctors. We take the perpetrators or the victim to the doctor. They measure the age of the victim. What did I mean by witchcrafty ideology in my presentation? When I was talking about challenges we face in handling GBV cases, I mentioned social and cultural barriers whereby some people commit gender-based violence offenses, especially in the cases of sexual offenses like rape, due to ideologies of witchcraft. They are told by the witch doctors that if you rape a girl of 4 years, you will get rich. So they end up committing that, and some of them have done murder of young children like that. Another question was about specific laws that impact gender-based, the lack of specific laws that makes the GBV cases pile up. We really don't have the specific law for gender-based violence cases in Tanzania, but that has not made piling up of GBV cases before our courts or before investigation machineries like the police officers. These cases are dealt with in the laws that are there, and we don't have any sort of problem as far as I'm concerned, lacking the specific law to cater for it. Also, there is a question about technological and cyber crime act, whether it's sufficient. For us, we have cases where crimes have been committed and the evidence is electronic. We use the available laws, and we are always successful on this. There was also a question about critical mechanisms to manage GBV cases. We know the government cannot do everything. What the National Prosecution Office is doing is to prosecute these GBV cases as they come. So first, the National Prosecution collaborates with other stakeholders to educate and empower community in the areas which is mostly affected, like the place where I'm working, Temeke, in Dar es Salaam, the whole of Dar es Salaam, Temeke, the cases of GBV are very severe. It is very, there are some places where it's prominent. So we have some schools where we recruit children and we empower them in clubs, so that when they go to their homes, into their places of residence, they can assist the community at large. We have this in Temeke, but not in other districts. We also collaborate with other NGOs and partners who do other aspects in trainings and things like that to the community at large. Thank you. I think I have answered most.
Oui, alors la première question, je crois que c'était sur le verset coranique de la sourate 4, le verset 34, que j'ai mentionné dans ma présentation. Il s'agit du verset souvent qui sert de justification pour dire que le Coran dit qu'il faut battre sa femme. Parce que en réalité, le vrai problème à propos de ce verset, c'est l'interprétation qui est faite du mot « varaba ». Et ce que je vous ai proposé, moi, c'est vraiment une étude, comme je vous le disais, à travers les outils contemporains et modernes des sciences humaines et sociales, c'est-à-dire la philologie qui combine des outils comme la linguistique, les études littéraires historiques, et du contexte historique dans lequel un mot est utilisé dans une langue à un moment donné. Et puis aussi, il s'agit de comparer les différentes occurrences de ce mot dans un texte. Il s'agit aussi de revenir à l'étymologie du mot. Et ce qu'il faut savoir, c'est que la langue arabe est une langue polysémique, c'est-à-dire qu'un même mot peut avoir des sens différents, et vraiment des sens très variés et différents. Donc il faut étudier le contexte du mot dans la phrase, et puis le contexte général et global du message coranique, ici, et du message du prophète Mohammed et de la tradition. Est-ce que le prophète Mohammed lui-même a conseillé ou enseigné aux musulmans de battre leurs femmes? Et donc, voilà, on combine l'ensemble de ces outils pour pouvoir arriver à un sens qui relève vraiment du bon sens et qui va dans le sens positif. Alors, en ce qui concerne le mot daraba, on le retrouve 57 fois dans le texte coranique. Le premier, je vais vous donner 5 sens dans le texte coranique du mot daraba. Il s'agit lorsque Dieu dit à Moïse, frappe de ton bâton par terre. Frappe ton bâton par terre, et c'est devenu un serpent. Donc il a dit Idrib bi'asaka al-hajar. Donc là il s'agit de frapper un bâton sur un rocher. Donc on est loin vraiment de battre une personne ou de relations humaines. Ensuite on va trouver le mot an yadriba mathalan, donner un exemple. C'est le même mot, mais là il change de sens. Ou alors yadribuna fil ard, parcourir la terre. Yadribuna alayhum adh-dhilla, l'humiliation fut imposée ou s'est abattue sur eux. On retrouve un autre sens, c'est c'est un des versets que j'ai cités à propos du voile. Dites aux femmes de rabattre leur châle, leur foulard sur leur poitrine. Là aussi, c'est le mot dharaba qui est employé, mais il n'a pas le même sens. Là, c'est le geste de rabattre. Et donc, quand on analyse tout ça, et lorsqu'on analyse le verset que vous avez cité, je vais le dire, quant à celles dont vous craignez la rébellion, exhortez-les, éloignez-vous d'elles dans les lits et séparez-vous d'elles. Donc les lectures féministes aujourd'hui, qui sont très critiques des lectures patriarcales, et c'est normal, nous devons, nous les femmes, faire ce travail, c'est notre responsabilité. Il faut avoir le courage de le faire et de confronter les lectures patriarcales et de proposer des lectures qui nous sont favorables à nous, les femmes. Nous ne pouvons pas accepter qu'un texte soit interprété au détriment de nos droits. D'autant plus que la langue arabe permet de faire cette interprétation qui donne le sens au mot dharaba, le sens de « séparez-vous d'elle ». Donc, c'est le mot « séparer » qui doit être pris en compte en ce qui concerne ce verset coranique. Voilà. Alors, en ce qui concerne... oui, alors j'ai eu une question sur... oui, est-ce que les lectures émancipatrices des femmes, est-ce qu'on ne risque pas de nous opposer l'argument selon lequel il s'agit d'un impérialisme occidental? C'est bien ça la question? Oui, bien sûr, bien évidemment. On peut toujours... je pense non seulement qu'il faut sortir de ce complexe de la comparaison sans cesse aux anciens empires colonisateurs. En fait, nous avons le droit de prospérer, de nous épanouir, nous, les peuples africains, en dehors de ce référentiel. On a l'impression que le bien-être est réservé aux peuples occidentaux. La bienveillance, le bien-être, le fait de ne pas battre une personne, la non-violence, on a l'impression que ce sont des concepts qui viennent uniquement de l'imaginaire occidental. Or, c'est complètement faux comme base et comme point de vue. Nous pouvons repartir à partir de notre histoire à nous, des histoires africaines. Et de l'histoire, et je crois qu'à ce propos, il faut aussi travailler sur les narratifs qui valorisent les histoires des femmes africaines. Et je voudrais à ce propos juste vous donner un petit exemple. Mon prénom, c'est le prénom d'une reine africaine, Kahina. La Kahina était une reine au 7e siècle sur toute la Numidie, l'Afrique du Nord. mais qui connaît l'histoire de cette femme en Afrique? Moi, j'ai envie de lancer un appel aujourd'hui aux historiennes, s'il y a des femmes qui s'intéressent à l'histoire des femmes africaines et des femmes qui étaient au pouvoir en Afrique, qu'on écrive un livre ensemble pour mettre en valeur les histoires de ces femmes, pour redonner aux femmes des modèles, un référentiel qui leur permettent de retrouver du pouvoir, to empower African women, mais à travers l'histoire africaine. Et nous avons de quoi trouver des histoires inspirantes dans notre propre histoire. Et le bien-être et la non-violence ne sont pas réservés aux pays occidentaux ni aux impérialismes occidentaux. Et juste un autre facteur aussi, il faut aussi que les peuples africains arrivent à comprendre que l'émancipation des femmes est un facteur de prospérité et qu'il faut travailler là-dessus pour arriver à la prospérité de nos économies, des politiques, de nos sociétés. Il faut que la femme aussi puisse être émancipée, qu'elle puisse accéder à tous ses droits tout autant que l'homme. Et notre histoire peut nous inspirer cela. Alors, la personne qui a parlé du mouvement Moussawa, je crois que c'est ma sœur qui vient d'Égypte. J'ai pas très bien compris sa question. Je crois que vous parliez. I think that هل ممكن أنك تعبري عن سؤالك باللغة العربية؟ لم أفهم.
No, it was just a comment that in addition to what you said, maybe the rest of the group can also check Moussawa production or knowledge production. So it's just a comment, not a question. Thank you so much.
Oui, alors il y avait une question aussi concernant le conflit entre le hadith et le Coran. Alors oui, bien évidemment, on retrouve dans le fiqh, dans la jurisprudence musulmane, des positions de certains ulémas, de certains juristes musulmans qui vont vous dire que le hadith peut abroger le Coran. Et ça a été vraiment un débat qui a traversé des siècles de réflexion à propos de l'abrogeant et de l'abrogé. À l'intérieur du Coran lui-même, est-ce que certains versets coraniques peuvent abroger d'autres? Et puis, est-ce que le hadith peut abroger des versets coraniques? Alors aujourd'hui, comme je vous le disais, les études en islamologie, la recherche en islamologie remet complètement en question ce type de procédé, ce type de mécanisme. Parce que ces mécanismes, ce qu'il faut savoir en fait à propos de la jurisprudence musulmane, c'est que souvent, c'était des traditions et des coutumes locales. Et lorsque un juriste, un faqih, voulait, ou une école, lorsque on voulait faire d'une tradition une règle religieuse, eh bien on allait chercher dans les textes sacrés, le Coran ou le Hadith, un fondement pour légitimer telle ou telle chose. Or, ce n'est plus comme ça que les choses devraient fonctionner. On doit prendre le texte, en dégager l'esprit du message qui, normalement, est là pour nous enseigner le bien-être de l'être humain, son émancipation, son élévation spirituelle. Parce qu'il s'agit aussi et avant tout de spiritualité, d'élévation spiritualité. Et d'ailleurs, lorsqu'on fait la lecture des textes uniquement sur la question de la norme ou de leur forme extérieure et qu'on oublie que ces textes sacrés sont venus aussi avec un message spirituel, eh bien on passe à côté du vrai message des textes sacrés. Oui, et monsieur m'a posé la question sur les outils et la méthodologie que j'utilise pour, là par exemple dans ma présentation, c'est ça ? En fait, justement, ce que je vous ai présenté permettait, j'ai fait exprès un peu de vous montrer quels étaient les différents sens que pouvait avoir un mot. En fait, j'ai pas montré toutes les méthodes que l'on peut employer dans les sciences humaines et sociales, comme la philologie par exemple. La philologie, On peut en philologie prendre un mot, essayer d'étudier l'histoire de ce mot, sa linguistique, le sens de ce mot, la diversité des mots, comment le sens du mot a évolué dans le temps. Par exemple, sur le mot djilbab, qui est employé aujourd'hui pour désigner ce vêtement noir qui couvre complètement la femme. Eh bien, justement, il y a des études philologiques qui ont été faites pour retrouver historiquement au 7e siècle ce que ce mot voulait dire. Et donc, il a fallu vraiment aller chercher dans toute la littérature arabe du 7e siècle. Donc, vous imaginez, ce sont des livres et des livres, des volumes entiers, des dictionnaires, pour retrouver comment, dans l'imaginaire arabe du 7e siècle, ce que voulait dire ce mot. Voilà une méthodologie, par exemple, que l'on emploie dans la philologie. Et puis après, comme je vous le disais tout à l'heure, l'islamologie emploie toutes les sciences modernes des sciences humaines et sociales. L'histoire, l'anthropologie, l'ethnologie, tout cela permet de voir à quel point sont combinées en fait les traditions et les cultures. Et ça, on peut le retrouver dans l'histoire des peuples ou dans certaines pratiques. Et on voit à quel point, en fait, cette histoire ou cette anthropologie a un impact sur la façon dont on va interpréter le texte et le comprendre. Donc voilà, ce sont toutes ces méthodes, elles sont diverses et variées, mais elles permettent vraiment aujourd'hui aussi de jeter un regard critique sur les compréhensions, les interprétations qui datent quelquefois de l'époque médiévale et qu'on veut absolument maintenir coûte que coûte encore aujourd'hui. Alors que nous devons évoluer dans notre façon d'interpréter ce texte et le faire à l'aune des défis qui sont les nôtres aujourd'hui, comme par exemple l'émancipation de la femme. Et comme je le disais, il s'agit là d'un facteur aussi, d'un facteur de prospérité des pays africains. Voilà, merci.
Merci beaucoup. Et, on peut applaudir encore. Même si on a faim. Alors, on prend pause. On va prendre notre déjeuner.